We're going to go ahead and get started. You're at the Greater San Diego Association of Realtors. There's my name. There's my telephone number. There's my email address. We're going to be talking today about the Buyer Representation Agreement exclusive. And I'm really excited because we're going to talk about paragraph number 3, commissions. I just got off of a conference with the Deputy Commissioner for the California Department of Real Estate, and I just love listening to Veronica. And so I have a whole bunch of stuff I'll immerse in here with you for all that. Okay, so we'll be talking about stuff that's going to sound like it's legal. It's not legal. I don't give legal advice. I'm really clearly not interested. I do better as a real estate agent, not a practicing attorney. I do a lot of trial work, but as an expert witness on standard of care and things like that, usually in the defense of real estate brokers. So not intended to be a substitute for the advice of your broker, nor for that of your attorney. Please consult with them as appropriate. And again, I got to change this slide. You are automatically going to get access to everything that I talk about today. SDAR has just stepped up. Jane Fabulic is just a wonderful person. She decided, why don't we just send them everything you're doing rather than you having to respond to 30, 40 emails. And so you'll get that automatically. So if you have other questions for me, Kevin at BurkeRealEstateConsultants.com. And people ask me all the time, are these being taped? And the answer is yes, they are. So the tape's going to show me, but it's not going to show you. By the way, I was just looking at a tape the other day. It doesn't even show the questions. And that's one of the reasons why I repeat the question. If you have one, I'll usually repeat it so that you can, that I'm getting the question right. And I would recommend that you do that with your clients as well. Am I getting the question right? And then B, I like to give you the answer. That way, for those of you who can't see the screen, at least you can know what the question is rather than me saying yes, no, yes, kind of like that. So that's kind of where that is. Anyway, I want to thank you all for being here today. I'm going to go ahead and take us over to the next slide, which is we're going to start our presentation today. And we're going to start it talking about our subject matter, which is our compensation to the broker. Okay, so compensation to the broker. So listen, I know we all like to be in charity. Hi, Claudia. Welcome back. We all like to be, we all do. I always say this to, hi, Serena. I say this to people all the time. I give to a lot of charity. I just, I get to pick my own charity. So you and I, when we get into real estate, the anticipation is that we're going to make money doing it. Some of us get in, think we're going to make millions of dollars, and some of us actually do. And then others of us, are just here to just kind of get by or to help people. I mean, I think the biggest thing is if you're here to help people, you'll do fine. So we do want to talk about, whoa, here come the questions. That's fast. What is the name of the form you want to discuss? The Buyer Representation Agreement. That's what we're here today. Buyer representation. Daniel, did I get the wrong one? Buyer representation agreement. I'm pretty sure that's today. We're going to do buyer representation agreement. Tomorrow morning, we're going to do CRS tax data. And tomorrow afternoon, we'll do the residential purchase agreement. We actually finished the residential listing agreement. And so we do everything by quarters here. So I usually pick up and fix and do the buyer representation agreement right after that. So the actual document that we're talking about is the buyer representation agreement. So again, the buyer representation agreement is the equivalent of the listing agreement, where in the listing, the residential listing agreement, you list a property for sale. You sign a contract with a seller. In the buyer representation agreement, you sign a contract with the buyer that says that you will represent them in a real estate transaction, but that you also expect to be compensated. Okay, and so one of the big questions that usually comes up is, and we'll talk about what happens if someone else compensates you. But remember that across the country, and I teach this concept and the form, by the way, and it has variances in different states where I teach it, but the general rule is that you must have an employment agreement in order to receive compensation from a client. So I know that in the state of Southern California, we get a lot of pushback on commissions, where of course we're afraid to ask for them for one thing. For another thing, we just take whatever we can get. But I'm going to tell you that you do have something to fight for. And so, you decide what that figure is going to be. Your broker has an obligation at law to establish a minimum commission in terms of listings, in terms of sales, things like that. And you at least have to make an attempt. So you have to look to your original broker or your employing broker to find out what your agreement with them does say. Okay. okay? All right, so what we're going to talk about today is the general document, which is the buyer representation agreement exclusive, and we're talking specifically about paragraph number 3, which is literally going to take, just like on the listing agreement, it took us a whole hour and a half to discuss that. So today, probably an hour and 15 minutes, somewhere thereabouts. Okay, so hopefully I answered your question on that. But if you have questions, please bring them in. I like to take a look every once in a while, see who I've got on the. Hey, Linda Hernandez, Nancy, welcome back. Cool. Now we have quite the crowd today. Okay, so let's talk about compensation. So none of us likes to work for free. And the two names that I just mentioned, if you've been in this business like we have for any period of time, we just don't need one more client calling us up and telling us how happy that they are, how happy we should be that they found a house of their dreams and that they wrote the offer through the listing agent, or they walked into an open house and the agent said, if you write the offer through me, I'll get you a better deal. Or they go in a new home subdivision, and in a new home subdivision, the developer says, well, your agent's not with you, so we're not paying you. So a lot of times we need to protect our own interests and our own time. At the same time, we need to explain to the buyer why it's important for them to have an agreement with us. And so, yes, a lot of people say to me, well, it's all about getting paid. And the answer is, so is the listing agreement. And the answer is, so is the purchase agreement. All these documents are all about getting paid, right? No, they're not. They're all about representation, and the getting paid part is ancillary to it. So we're going to see, you can put whatever figure in here you want. I mean, it's up to you. Whatever you want to charge your client is up to you. And then like we do in our office, if there's a discrepancy between the amount of money that the listing agent pays us and the amount of money that our buyer has agreed to by contract, then it'll be up to our agent to forgive or not forgive, or housewarming gift or whatever. But at the end of the day, we need to have an employment agreement for one thing, and number two, you have to have an agency relationship that is created by contract. Okay. All right. And it's important, if you do a buyer representation agreement, you need to notify the listing agent when you're showing the property, when you're going to write the offer, that you do have a buyer representation agreement with your buyer. Okay. And I'll talk to you today about some things that I say that usually get the listing agent to want to, make sure that I'm getting compensated to a level that I think I'm worth, rather than whatever they put in the multiple listing service. So that's all. But it's whatever, people are going to do. We're not going to establish a commission. We're not going to set a minimum. We're not going to do anything like that. That is a total Sherman antitrust violation. And so we're not going to get involved in that conversation. So, my office has a policy. Your office has a policy. The DRE requires that your office have a policy. So, it just is, unless you're a sole proprietorship. But, that's just kind of how that is. So, okay, so let's talk a little bit about this. So, you're working with a buyer, you've taken them out and you've shown them, you've had this conversation with them. And as we did the appointment, as we did the presentation this morning, how to create a winning listing presentation, one of the biggest points that I emphasized in that webinar this morning was that the more time you spend with the client before you get to the other stuff, it'll be worth miles for you. So in other words, I'm going to sit down with my buyer and I'm going to spend at least an hour, maybe 2 hours, maybe more, just going over the agreement, going over how I do business, going over Ken Kaplan, who I love Ken Kaplan, he's a super guy, and he calls it the buyer loyalty agreement. And so, I think that might be a pretty good word for it. But, does your buyer have an understanding of the agreement? And that's why here we are at SDAR, and we are doing these presentations so that you can get an idea of, how to sell the tools of your business. So that's what we do. We didn't get a license just so we can hope that someday somebody will feed us. We got our license because we anticipate helping people, but then we expect to be compensated for that. And that's what this is all about. Okay. So we're going to talk about this in depth. And again, this is an interactive class. I want feedback from you. If you have questions, please type them into the Q&A field down at the bottom. I look at it as frequently as I can to see, if there are any questions, and or raise your hand or do anything like that. And we'll go ahead. Hi, Galena, welcome back. And we'll go ahead and talk about that. Okay, everybody good? All right, so I'm going to move forward. So let's talk about, I love to annotate things, right? So I'm going to pull up my annotation tool and we're going to talk, we're going to go deep on this. Okay, all right, now, Here's my keyboard because I don't need that anymore. So now we're talking about compensation to the broker, okay? And that's the key word, compensation. Remember that the DRE says that you may not receive commission or any kind of compensation in an agreement with a client unless you have a written employing agreement. So for example, if, you know, a lot of us just think, well, we're going to write an offer on a property that's for sale. And so, you know, the listing agent has a contract. We're a TPB is called a third-party beneficiary of the listing agreement. So I'm the buyer's agent, right? But I'm getting paid by virtue of the listing agreement. Okay, I'm assuming that they have one. I'm assuming that that listing agreement says that I will be compensated. But remember, when they take the listing, they set the terms of the compensation. They set their own terms of their compensation, and then they also set the terms for the compensation that they're going to pay. And they have to put it in the agreement, because this is what we actually created it, because a lot of times brokers were taking the commissions at 10%, and then paying the buyer's agent $500. And so one of the reasons that we put in the paragraph 3D of the listing agreement was that we wanted the listing agent to inform the seller at the time of the listing what the amount of compensation to the other broker was going to be. And that's why we added that language in there. So the reason I don't care what the other agent puts in the listing agreement, whatever it is that they're going to have, that they're going to tell the seller that they're paying us, I don't care. I really don't. When I look in the multiple listing service, sometimes I see in there that it's compensation that I'm used to receiving. Sometimes I'm seeing that it's more compensation than I'm used to receiving. Sometimes I see that maybe less compensation, but I never worry about it, because I know I have an agreement, an employment agreement with my buyer that says that the buyer agrees to allow me to represent them, and that's the most important part. And then number two, compensate me for my services. Everybody understand? I mean, if you think about it that way, it makes a lot of sense. All it is that I'm going to work with you, and you agree to work with me, right? Love at first sight. We're going to do that, okay? And so you need to make sure you have that agreement with your client. And I'm telling you that only in the state of Southern California are people just go crazy about it, and then they don't want to. I don't want to ask anybody to pay me. I'd never sign one. I mean, please feel free to put all the objections in here today, okay? I'd never sign one, okay? And I always say, really, have you ever read it? Or I think that that's too much to ask, or the buyer won't work with me. And I go, well, maybe you don't want to work with that buyer. Okay. We're not asking the buyer. We're asking the buyer to compensate you in the event that someone else doesn't. And that's the most important part of it. Okay. So this is really what was this part, absent any of that other language, what does this protect you from? This protects you from the buyer walking into a new home subdivision and the developer saying, we're not paying the agent because they weren't here when you walked in. Okay. This protects you from the buyer buying the property from the seller directly, for sale by owner, right? Okay. So, or this protects you from the buyer making a deal with the open house agent to be compensated, or to do the transaction through them. This is to protect you from when the buyer ends up going to someone else and not having you represent them in the transaction. Now, the onus is on you, folks. The onus is on you to explain this to the buyer. Don't just have buyers sign things and just say, here, everybody signs it, or this is the way I do my business, or stuff like that. I hear that all the time, right? The bottom line is you have an obligation when you sit down with your buyer. Remember, an hour, 2 hours at least. You sit down with your buyer and you say, hey, here, thou shalt not go into new home subdivisions without me. In fact, this weekend, you and I, we're going to go driving all around all San Diego County, and we're going to look at every subdivision with, that has your price in it, right? Okay, so, but you have to tell the buyer these things. You don't want to blindside them. You have to tell them, thou shalt not, negotiate with a for sale by owner without me. You've agreed to allow me to represent you, okay? Now, it seems like it's such a hard conversation for some of us to even think about. I mean, I see people just going, oh my God, how am I going to do that? You have a harder conversation with the listing agent. I got to tell you, I think it's easier to get the buyer to sign your buyer representation agreement than it is to get your seller to sign the listing agreement. Okay. I really do. Okay. And frankly, I teach this all over the country, right? And in every state, again, except the state of Southern California, in every state, the buyer is waiting for you to bring this form out. In other states, the buyers say, hey, and I teach brokerage, get your broker's license in Virginia. I teach it in other states. And so they're saying, yeah, what's the problem? We all do this. We're not allowed to work with the buyer without it. The law says we have to do it, have to have it, okay? Discuss disclosure regarding real estate agency relationship 2 pages prior to the buyer decision. Yep, I can, Daniel, I'll talk about that in a couple of minutes. We've already done the agency disclosure, but I think you're right on. I think we need to have this conversation again. I think we need to have the TDS again too, because there were some changes made to the TDS and there have been some changes made to the disclosure regarding real estate agency relationships. So let me catch up on that as we get towards the end of this, but I definitely want to cover that. We'll have time to do that. Agency is really important. And as we said in this morning's class, I think you need to present it to your client and you need to make sure that they are understanding it. Okay, that's kind of our job to do that. Okay, thank you, Daniel. Good question. We're going to hit that in a couple minutes. Whoops, my screen got paused. Why? There we are. We're good. Okay. All right. So where was I? I was on a track here. So you intend to get paid in a real estate transaction unless, again, as I said earlier, you like doing charity and you like working for free. You need to have that employment agreement, but we can't blindside the buyer by saying, well, wait a minute, you signed this document. And the buyer says, well, I didn't know what I was signing. I just signed it because you told me to sign it. Okay, so you don't want to have that conversation. You got to have, like in every other contract, you got to have a meeting of the minds. Everybody has to understand what they're signing. All right, and so that's why, again, I counsel you to sit with the client, go over the form. Don't be afraid of it. That's why we're doing this. We're reading through the form. We're going through it. You will never spend this much time with a client as I am spending with you to explain how to explain the form. So I'm hitting every question you can possibly have, and you're not going to have half of them, right? But it won't take you this long to get through it. I mean, I can get through a buyer representation agreement with a buyer in less than 15 minutes. Okay, compensation part, I'm spending a lot of time with you on it, but it's just so that you understand how you're going to explain it. So here's the big, you've seen this language before, notice, okay? So notice, you've seen the same language on the listing agreement, okay? So we have our buyer representation agreement, we represent the buyer. We have our residential listing agreement, we represent the seller. Both of them have the same language, and there's only going to be a couple little nuances to it that are going to be different. The amount or rate of real estate commissions is not fixed by law. That is the most important thing. There's so many people who say, well, the law says this is how much I have to charge you. There is no law. In fact, it's against the law for you to suggest that there is a law that says that this is how much our commissions are to be charged. Okay. There's also a law that says you may not negotiate with other brokerages for purposes of everybody agreeing to pay, to charge the same amount of money to a client. So you may not do that. That's against the law. All right. And if you want, I don't want you to attend my law class, but when I teach my law class Thursday night, we're going to be discussing this very same thing. It's against the law. Okay, so you may not have that conversation. So the amount, which is a dollar amount, or the rate, which is a percentage of real estate commissions, is not fixed by law. Everybody's understanding that. You don't want to leave the client with the impression that it is. You certainly don't want to be telling the client that it is. You tell the client, this is how much I charge, and then that's the end of it. And that's going to be based on whatever your broker has established as a minimum. But again, we don't want to lead anybody to believe that there's a law that says this is how much the commissions are supposed to be. They are set by each broker individually. So the broker establishes how much the minimum commission needs to be. And if you don't know what that is, pull up your office policy manual. It should be in there. It should be in your contract with your broker. Okay. So it tells you how much you're supposed to be getting from the client. And the reason is because the law requires your broker to establish a minimum commission, right? The broker has to establish one, but it's only individual to the broker and only among the agents within the brokerage firm. It is not established outside with other firms. So every time you got a different broker, so like you may be with a big corporate, big company that has a broker, and then maybe the company that's a franchise down the street with a different broker, different deal. Okay. They cannot get together. I mean, I know a very large brokerage company that got in trouble in Southern California for, everybody kind of fixing the amount of money that they were going to pay their agents in commission. So we're not going to do that. Okay. All right. They are set by each broker individually, and the operative word may may be negotiable. And I can just see Nancy and Linda laughing right now because they've heard me do this presentation so many times. And you know, I always say it may be negotiable. And so when the client says, well, will you do it for this amount that's less than what you're asking me? I say, no, it just says it may be negotiable. It is not made for me. For me, it is fixed. I have a certain amount that I charge and I don't deviate from that. But it may be negotiable. The law says I have to tell you in bold print. Okay, this is all bold print. The law requires this. All right, in bold print, I have to tell you that commissions are not fixed by law, and that the broker, you may be able to negotiate with your broker. You may not be able to negotiate with your broker, but it's all a negotiable item. Okay, so as my clients, if they were ever to press me for stuff, I would always say to them, I would say, well, yeah, right, it does. It says it may be negotiable. Up. Who said it has to go down? I love that part where they go, well, I thought you would negotiate your commissions. Sure, I'm happy to negotiate. Okay, how much do you want in commissions? I want 10%. And they say, okay, will you do it for 9? I go, no, I'll do it for 11. Okay, remember what we said this morning? I always bring my sense of humor to the table. They're afraid of you after that, right? They're afraid to ask another question. Okay, but I always tell them, say, yeah, it could be negotiable. Not here. I'm not negotiating it. Okay, and yeah, but who said it has to go down? It could go up. I like up. Up's a good number. Okay, so and this is the difference between the listing agreement and the buyer representation agreement, is that this would say the seller on the listing agreement, and then the broker, of course, stays static. Okay, real estate now. Okay, so everybody cool on commissions? All right, I just want to make sure you have to establish what the commissions are. Now we're going to talk about what those numbers could be, but for right now, we have to tell the client that they may be negotiable by law. Okay, and in fact, they are negotiable by law. Okay, but they may be negotiable between the buyer and the broker. So the broker may have a policy. This is how much I charge. I'm not going to do it for less than that. Listen, I think there's value to what I bring to the table, right? And so do you. You have value. I mean, you have a real estate license. You worked hard to get that license, so you have something to fight for, and you have kids to feed and all kinds of stuff, and you're doing something of value for a member of the public who may or may not be licensed. I mean, I do represent a lot of licensees, but may or may not be licensed, and so you need to at least have this conversation with them. Okay, is everybody good with that? I'll try not to get quite as animated as I did this morning. I was having so much fun this morning. It was beyond compare. I was having a great time. So, but let's talk about the next. Well, first of all, let me check to make sure. Any questions? Any questions about any of that? No, not yet. Okay. And Daniel, just to add a little bit to your question. So my agency disclosure on page 1 of the CAR form AD explains what it means for me to be representing the buyer. And so your question is a good one. In this document, since this is the buyer representation agreement exclusive, I don't know if I'm going to be I know I'm going to be at least a single agent, but I don't know if I'll also become a dual agent, right? So I don't know if I'll be writing an offer for this buyer on one of my own listings or on one property listed by my broker, okay? So I don't know. At the time that I get the buyer representation agreement, much like at the time I get my listing agreement, I'm representing only single agency. I'm the single agent either for the buyer or for the seller. I don't know if later on when the buyer finds a property they want to buy that we write an offer, is it going to put me in a dual agency situation? And that's when I'm going to confirm agency on paragraph 2 of the residential purchase agreement. Okay, so the law says you must disclose the concept of agency, but then you must also confirm agency later. And that's why I like to have that conversation, because then when I get into this, they realize, oh, I get it. You don't all pool your money into this little jar and then everybody takes it out based on how many hours you put in. That's not how it works. Okay, all right. So let's talk about subject number 2. I want to talk about all within this parents right here, okay? And this is kind of a fun one. So real estate commissions. So this is the part where we get cute. And again, I was just on with Veronica just earlier, half an hour ago, and I was talking about creative realtoring, okay? Some of the crazy things we see. So real estate commissions, okay? So the DRE says, we don't care what you call it. Include all compensation and fees to the broker. Okay, so the DRE says, listen, we're going to give you the regulation, we're going to give you the rule on commissions, and then you can call any money that you get, you can call it anything you want to call it. We have created a rule that says any money that you get, we're going to call a commission, and that commission is any money that you get. Right. And so here's the rule that applies to commissions. And that is, we have to tell everybody that the amount or rate of commissions is not fixed by law, et cetera, okay, just like we've been saying. So again, the DRE says, you got, you charge a TC fee, or you charge an administrative fee, or you have all these fees that you're going to charge people. DRE says, we don't care what you call it. We're going to just, any money that you get, we're going to subject to our regulation that says that it's a commission. We're going to put it in that bucket that's called a commission. And here's our rules based on commissions. Okay. Everybody good with that? All right. Okay. So I think I hit all the points on that, but and I mentioned admin fee. So you all remember the Quicken Loans case where Quicken was charging a $250 administrative fee on all their transactions. And of course, then they got looked at, they got scrutinized, and it turned out that the admin fee didn't do anything. And so in my conversation with Veronica about 3 years ago, we discussed TC fees and charging those to the buyer and charging those to the seller. Again, even if you put it in the associated contracts, and the nuance of it is that her comment was, we're going to say that you should just go ahead and include that in your bundle and not make it a separate fee. So we as an office stopped doing it years ago. Again, I love talking to Veronica because then I go, okay, I get it. All right. So now, but we go in there and we charge, maybe we take a buyer representation agreement, maybe we charge 3.5%, but we don't charge any TC fees. I mean, you work it whatever way you want to work it, but remember, you can also charge by an amount. So you can figure out mentally what's 3% of $1 million, and then add whatever your TC is, 350, 450, whatever. So now your commission is going to be $30,450, and then you can just put that in here. So you can just do a dollar amount on line number 2, and rather than going with a percentage of sales price. Everybody follow me on that, assuming that that's important. Remember that where TC fees came from was back in the early 90s. And we discovered this when I was management at one of the brokerages, big brokerages, and who's no longer in existence. But we were finding that our agents were, not getting their files completed, not getting the files in, and so then we're fighting them for that, before we pay them a commission. It was just a great big fight. So, we created transaction coordinators to help the brokerage take care of making sure that files were complete, because we knew our agents weren't doing it. That was the genesis of the transaction coordinator. That's where it all started. And so we realized that we needed to have some kind of a mechanism for ensuring compliance with the file. Well, what happened was we would charge our agents, at the time, I remember it's $250. We charge our agents $250 for the transaction coordinator, and then we were fine, because the transaction coordinator would make sure all the paperwork's done, all that kind of stuff. But again, we were charging the agent. And so that part of the business really started to blossom quickly, and other brokers figured it out, and everybody started charging these fees. In fact, in our office in Del Mar, we had 3 different transaction coordinators within our transaction coordinator department. And so then, but what our agents realized was, well, why don't I just pass that fee on to my client? And so then they were doing that. They weren't putting it in writing. And then finally, one day they realized, oh, I guess we're collecting a fee. We need to put it in some kind of a written agreement. And that's when it started showing up in the listing agreement, when it started showing up in the buyer representation agreement. And so, that was the genesis of the whole thing. But then, they started charging their client for it. And that's when the problem started happening. Okay. So, that's what the Department of Real Estate says, we think you should be earning that inside your commissions. So adjust your commissions, up, down, whatever you want to do. That's what you're going to do. Okay. So buyer agrees to pay to the broker. All right. Now, I know for some of us, we're sitting here thinking, God, it's really foreign to me. I can't imagine a buyer paying me a fee. You know what? I've never had one refuse me. Isn't that crazy? I have been doing this since 1977. And I've never had a buyer refuse to pay me. I just never have. I've never even had them negotiate with me. I guess maybe I've already established value before I've gotten to this point, and maybe we need to work on that, right? But, at the end of the day, they know that somebody's got to get, you got to get compensated. They're not expecting you to work for free. And they're not, listen, in 49 and a half states, they understand the idea behind the seller paying a commission and or the buyer paying a commission, okay? All right, so irrespective of agency relationships. And what does that mean? That means whether it's single agency or dual agency, they understand that they're going to have to pay the broker. Okay, that's what that means. All right, and again, it's really important to remember. Even if you look at your buyer representation agreement, you'll see that the place to initial down here on the bottom says broker's initials. It doesn't say the agent's initials, and so you'll see that, because that again is the employment agreement. I disagree with that, because I think that should be just like the listing agreement allows you to. Well, actually, we took it out of the listing agreement, didn't we? We took it off of all the pages. So now that I'm thinking about it. So, okay, so let's take a look. Amount, number A, amount of compensation. So it says here, check 1, 2, or 3. Okay, check only 1. Now, I haven't seen anybody mix that up for a while. Part of the reason is because we made it so you can only check 1 at a time. All right, but let's go through the scenario. So here's number 1. I can charge a percentage of the acquisition price. So whatever the buyer purchases the property for, I can get whatever figure. And you decide what that's going to be. And so remember, you're doing one side of this transaction. You're not signing an agreement with the buyer that says they're going to pay you and the listing broker. So, maybe you adjust your commissions appropriately. I don't know what that number is. You decide. In our office, we do 3%. And so I'm going to use that. Let's use that as a number just for the purposes of some of the conversation that we're about to have. Okay, so whatever the number is. Now, I say that that's our policy, our low end on our policy, but I can tell you that we have agents in our office that get more than that. I don't think I have any that tries to get less than that, because again, we have a minimum standard. So we have to set the minimum standard, and that also makes it easier for the agent to at least ask for something. Okay, all right, so if my compensation is 3% of the acquisition price, and then what? And so that's the part where we used to add in our transaction coordinator fee until Veronica said one day, we think we should be adding that, just covering that in your commissions. And so now we're back to that part where, we split our transaction coordinator fees with our agents because, we do, we run a transaction management company as well, but it's a separate business. Okay. So, and again, we support other brokers. We do other brokers transactions for them and things like that. We're not a transaction coordinator per se, but we are a transaction management platform. So that being said, so I don't know what you're going to put in here. This is big question mark. Okay, I don't know what you're going to put in there, but I think that I would probably cover it in whatever the figure is over here. Okay, that would be my advice. And then here's my or statement in bold print. Let's say we do or. It can be a dollar amount, right? It can be a dollar amount. So that saves you the trouble of having to do the math or trying to get a commission. So again, as I said earlier about the company that I was with, our agents were going out on listing appointments and caving on listings, because they were getting the lion's share of the money anyway. And then when we started hitting them up for the TC fees, then they started, kicking back on us and saying, hey, wait a minute, I don't want to pay the TC fee. And then we'd say, well, yeah, but we have a certain minimum that we have to just stay alive in real estate. And so, we put it back on our agent. We didn't put it back on the client. So anyway, bottom line is on number 2, I can just address that by putting in a dollar amount. That's it. $10,000, $20,000, $30,000, whatever, 100,000, 600,000, whatever figure that you think you're worth. Or if your client is looking in the price range of 100,000, it might have a different number in here than if they're looking in $1 million or if they're looking at 10 million or something like that. Okay. And then number 3, again, an or statement, pursuant to the compensation schedule attached as an addendum. Now, I haven't seen anybody do one of those, but I imagine it falls along the line of, for transactions under $1 million, I'll do it for 3%. For transactions from $1 million to $2 million, I do it for 2.5%, whatever. I don't know. Again, I haven't seen anybody do that. What I see when I see these agreements is I usually see it expressed as a percentage of sales price, and that's about it. And again, in our office, we don't allow anything to come after the and statement. So because, there's just, we can't imagine what you can put in there that we're going to have to defend. Okay. Everybody good with that? Questions on any of that? Again, I did a pretty good job of telling you that I'm not going to tell you how much you should charge. I think you should charge whatever you can charge. I think you get away with whatever you can get away with. But at the end of the day, there's no rule, except that we're not going to make one. We're not going to make a rule that says you have to charge this much. We're not going to do that. Okay. Everybody good with that? I'm also trying to kill the objections right now. This is the conversation that you and I are having. I'm trying to help you understand how to get past this with the client. So, your client would clearly appreciate your work and clearly wants to compensate you for your work. And so you need to explain this part of the form. Now, it's going to be up to you when you're having them sign it, how much time you spend on it, make sure they're clear about what it is that you're saying. Okay. And we're going to cover what happens if somebody else pays you. But at this point, they're going to assure that you get this amount of money. So you want to have the conversation with them. Do not, thou shalt, the 10 commandments of working with me. Number 1, thou shalt not walk into a new home subdivision without me. Thou shalt not write an offer through a for sale by owner without me. Thou shalt not write an offer through a listing agent on a property without me. Those kinds of things. Okay. So those are questions that you need to have, conversations that you need to have with your client. What if the property you're purchasing has a 2.5% for the selling broker? If you charge 3%, are you going to request an additional 0.5 point from the buyer in escrow? So Daniel, I'm going to say that, you know what, that's an excellent question. And the answer is yes, subject to what we're going to see on as I go to the next page. Okay. So great question. I always like that question because it's going to be, we have a great answer for that. Don, if MLS indicates 2.5, let's say we indicate 3, how do you resolve the discrepancy? I think that's the same question as Daniel's. So let's cover that right now. We're going to cover what happens in the event that there's a discrepancy between the amounts. So again, you and I, we're just gonna, for the sake of the class, we're gonna talk about that this number is 3%. Is everybody good with that? We're gonna talk about that we've made a deal, or I've made a deal, you've made a deal, whatever, you've made a deal at 3%, and then that'll make it easy for me to explain where we're gonna go next, okay? So 3B, which is at the top of the next page, by the way, and that's why you need to get to that part of the page, because this is the part that says what happens if somebody other than the buyer compensates you. And so remember, the law says you can't do double dipping. You can't charge twice for the same service, okay? The law says that you can't have secret profit. You definitely don't want to run afoul of that, right? So you can't have secret profit. You have to disclose to the buyer what the charges are going to be, okay? And that's why in the earlier page we did 3%, we did a dollar amount, or we did, you know, based on a compensation schedule as an addendum, okay? Now we're going to talk about compensation payments and credits, okay? So we talked about what the numbers would look like. Now let's talk about what happens if, okay? So buyer is responsible for payment of compensation provided in this agreement. So the buyer owes you, and in our argument, 3%, okay? However, let me get rid of some of my red here. So however, and this is a big however, if anyone other than the buyer compensates the broker for services covered by this agreement, okay? Now, who would that be? The landlord, the seller's agent, anyone other than the buyer. So the buyer has an obligation to cover you, in our case 3%, but if anybody else compensates you, then that would be credited. It's what's going to say right here, that amount shall be credited towards the buyer's obligation to pay commission, okay? So let's talk about our scenarios, all right? We're going to talk about scenario number 1. You put in 3%, and again, this is just a number. You put in 3% compensation. The buyer has agreed to compensate you 3% for your work, okay? So now if the buyer goes someplace where you don't get compensated by someone else, then the buyer is going to owe you the money, absolutely, okay? That's just part of the deal, okay? But what happens if someone other than the buyer compensates you? And so let's use our number of 3%. So if we're saying 3%, and the listing agent put in that the compensation to the buyer's broker, CBB, is 3%, then it's a wash, right? 0. Now you say to the buyer, you don't owe me anything because it's a wash, okay? All right. Now, I know what you're thinking. So you're thinking, what happens if the commission in the listing agreement, because the listing agent is buying into the fact that he thinks all the listings are at 5%, right? So what happens if it says in there that the listing is at 2.5% to the buyer broker? And the answer is now the buyer does have to pony up 0.5 point. Okay, so what I mentioned in the beginning of our conversation today is, you know, that 0.5 point in our office, at least, you know, we want our agent to at least get an agreement that says 3%. Okay, and then if there's going to be an adjustment to it, the agent, we get into a conversation with our agent that says, all right, you can forgive the other 0.5 point, or you can give it as a closing gift, or there's a lot of things that you can do, but you may not tell the buyer, don't worry about it saying 3%, I'm not going to charge you. If you do that, then you create an illusory contract, and you don't want to do that. Okay, it's a lot like when you take a listing on a house and you tell the seller, well, don't worry, I'll let you out a listing at any time. You know, when you have a conversation like that, you've created an illusory agreement, which means it's not real. And so, you know, you're not going to be able to enforce it. And I know because I've been in a position where I was unable to enforce it for a brokerage where I was management, when our agent was telling the sellers that they could get out of it at any time just by a phone call. Okay, so in my scenario where the listing agent is only the offer of compensation, let's put it that way, the offer of compensation in the MLS is 2.5%. Now I've got a discrepancy, and I've got a 0.5% discrepancy in the commissions. Okay, so the buyer has agreed to pay me 3%. Now let me ask you a question. How much money do you think that is? Okay, so let's say it's a $500,000 property, right? Our mean sales price, our average sales price is a little bit higher than that. $500,000 property. So what's 3% of 500,000, right? Everybody with me? $15,000, right? Okay, but the listing agent is only, I'm sorry, the offer of compensation, the unconditional offer of compensation is 2.5%. So what's 2.5% of 500,000? Help me out. Okay, 2, 10. Okay, so 12.5, right? Good. Okay, so here's the difference between the commissions. The difference between the commissions is going to be $2,500. Okay. Now, remember what I said earlier? I've never had a buyer deny me. First of all, I've never had a buyer deny me signing the agreement. Secondly, I've never had them complain about the difference in the commissions. Okay, never. I mean, and guess what? And so what happens? Escrow puts it onto the escrow instruction as a buyer's fee, but the buyer needed to be made aware of the fact that they were going to pay the fee. You can't do this if you don't have a written agreement. If you don't have a written agreement, you're stuck with what's in the listing. Okay, so I don't want you to take the easy path that says this is way too complicated, I can never do this. I want you to take the path that says I'm worth what I'm working for, and I deserve it. And I want you to at least ask for it, because if you don't ask for it, you'll never get it. But look at my difference. My difference is $2,500. They're buying a $500,000 house. You think $2,500 matters to them? Okay. But like I said, in our office, you know, we talk to, if it looks like our agent's establishing a pattern of rolling over on it, then we're going to have a different conversation. But if our agent says, well, you know what, I'd give them a closing gift. I can't write, you know, a closing gift off more than $25 according to the IRS. So, you know, maybe I'll give them half of that or whatever. But again, the brokerage is entitled to the $2,500. So the brokerage, our brokerage at least makes the decision that will allow, you know, that the buyer's agent at least has to apply for it. And then we'll discuss how to handle it later. And by the way, if they're having trouble with questions about commissions, then I'm going to take responsibility for that. I'm going to say it's because I did a poor job of teaching, and then I'm going to go ahead and reteach. Okay. All right. And then you got to listen to me again. Okay. How would you structure the commission if you represent the buyers sell their home and you granted a discount on the commission for purchasing another property? Again, I don't know what a discount is, Daniel, because I can't really say that because I don't know. The discount implies that it's something off of a normal or customary or usual, or everybody does it, excuse me, or nobody will look at your house, you know, unless you pay this much. Those are the kinds of things I want to avoid a conversation about. But you know what? You're right. Maybe I make a deal. Maybe the buyer says, well, you know what? I'll tell you what, I'll let you sell my house. And 99% of the time they're moving up, right? I'm going to sell my house for 500. You're going to sell me a house for $1 million. Maybe you make some adjustments, but again, that's going to be a good question with your broker. Okay. So, you could remember commissions are maybe negotiable. So they may be negotiable. You'll have to establish that conversation with your broker to find out what your broker wants you to do. Okay. So say 1% of purchasing a new property. If I was going to do, so let's take your scenario. If I was going to do a negotiation about my fee, I would usually want to collect the full 3% on the up property and collect the lower, you know, the 2.5%, if that's what I was going to do on this for sale property. So give them a break on the sale, but charge them the full 3% on the up end, because on the up end, that's probably, I may end up with a bonus for that. Okay. Rather than giving them a break down here. If there is a break, don't offer one unless they ask for it. I find it's one of the craziest things that we do is we start offering money. You know, I just did in this morning's class, I included earning your commissions, which was came out of a seminar, actually a company meeting that Steve Games did back in God, I hate to tell you, late 90s. And it was interesting. There was a poll that was done that said that 88% of the sellers that were asked, why did you discount the commissions, you know, that for the service of selling your home? And they said, because the agent gave it up walking in the door. Fascinating to me, right? The agent walks in the door and says, oh my God, I got to have this listing. I'll do it for nothing. I'll do it for $10, right? The agent gives it up. You know, why don't you earn it? You know, but the agent gave it up. Again, walking in the door. It wasn't like at the, you know, to put the deal together, you know, no, it's like you just gave it up. You just said, no, I'm not going to charge you. I'll do it for free. Okay. I just like to help the homeless. You know, I want you to become homeless and I'm just going to do it for free. So the answer is check with your broker on that. Do whatever your broker tells you to do. But it's just surprising to me that we don't realize that a lot of times it's us, right? My client asked for discount after I listed the property, and his son's friend said that another agent said it was customary in their company. And again, that's against the law. So, you know, we can't really have that conversation, but, you know, everybody's looking for a discount, right? You do. You buy, you have a Costco membership. You know, we all have memberships at places that give us discounts on things, but that's when we're discounting a product, not when we're discounting a service. Okay. So we did, so I can buy the same power washer at Costco and I'm going to pay, you know, $10 more at Walmart and I'm going to pay $300 more at Best Buy. I don't know. But at the end of the day, now I can compare those apples and apples. So you can compare price, but you can't compare service. And so you provide a service. And so, and there's always an interloper, right? So you got, what did you say? A son's friend said, another agent said it was customary. And then it starts to look like that story told around the room, which always cracks me up. We had that happen just the other night. You know, one of our agents went on a listing appointment and the daughter was there and the daughter says, well, such and such a company will do it for less. And you know, our agent of course was trained and they probably should. So I thought, what a great outcome. He shot the whole thing down, you know. And so it was like, not to make a disparaging comment about anybody, but they can't compete with me on service. They can only compete with me on price. So they maybe they adjusted their commissions to do something because they couldn't, you know, I'm going to bring a better quality of service. Remember, that's one of those things you could never really weigh. So, you know, at the end of the day, you know, imagine, and I'm just going to put this question out to you. I'm on a listing appointment. Am I bringing value? Seriously, do you think I bring value on the listing? I think I do. I mean, I really do. Okay. I think you do too. I think you bring incredible value in there. It's not just because you got your real estate license, but the fact that you actually care about your client. Okay. And I can tell you, I know a lot of real estate agents that really don't care. Okay. And you're just another number. All right. So you care. Never worry. There's always going to be somebody, but you got to be prepared. Remember how to create the winning listing presentation we talked about. You're going to have the conversation about commissions. Okay. Oh, now I can see. You can't see the questions. Oh, great. Okay. All right. So that literally you have an opportunity now to come up with some of these catchphrases. There are books written on what to say when they say this, right? I was with the Red people for just short of 3 years, and we had this huge book that we paid $750 for that had the answer to every objection that you would ever have, right? I mean, I was going through it. I couldn't find anything new, right? I mean, it was a monster book, and we wouldn't let you have it, right? Because we paid $750 for it. And if we give you the book, then you will get it back and a page is missing. And so, God, it made the broker, made the manager, wasn't even a broker, the manager insane. I mean, so, but at the end of the day, I'll help you with that stuff. I mean, there's going to be an objection. So ask for a discount. Of course, they all do. You need to know how to handle that. How do you handle the discount? So what we did this morning was I made available to you a whole bunch of stuff from Mike Ferry, Tom Ferry, all these other people that, you know, all have advice for you on, you know, how to discuss commissions and how to do things like that. Take a look at them and don't read the script. I mean, look at it, make it your own, make it sound like it's coming from you. I never cave on what I'm going to charge because I refuse to cave on my service. And so I just think of it that way. It's just a way for me to think about it. Okay. So I want to make sure I answer after I list the property. And his son's friend said that another agent, okay, so now they wanted you to reduce your commission on your property because somebody else said that their company does it for less. And I guess that's kind of the same question. Okay. All right. Thank you, Daniel. Good question, though. I like you asking the questions. Bring them on because this is important. Okay, we need to get rid of this. We need to make it so that it gets back to the issue at hand, which is not about the commission. It's about the service. It's about the service that you're providing for the client. And you know what? It's opportunity cost. Remember that from economics? It's opportunity cost. You could be doing other things. I tell my agents all the time, go to the beach. I mean, listen. First of all, our whole company, everybody in our company, they're not allowed to do a transaction without this. Okay, so they have to do it. Guess what? Everybody gets it. How hard is that? So it's not that the difficulty level changed higher or lower for them. It's just that they aren't allowed to come back in without it. And so now they just go ahead and do it. And most of them just do it because they know that that's what we got to do. All right. And guess what? It protects us. So you know, I know some of you on here right now have buyer representation agreements with buyers for us. And you know what? It makes you feel really good to know that they can't go around you on the transaction. So, and that's really the saving part. Because I know my business partner for 15 years, she comes in and she goes, I'm just so angry. You know, I showed these people 40 houses and then they went and bought a new home. And I said, did you have a buyer representation agreement? She says, of course I didn't. Why would I have that? And then it was my fault, something I had done. It's like, I told you what to do. Okay. I had an attorney friend of mine, super guy. I really like him. He's a broker. And he calls me up and he says, buyer went into a new home subdivision, but they were really smart. They go in there and they sign in, their name is Mickey Mouse, right? And then they says, I go back with them the next day. Now he's an attorney and a broker. Okay. I go back with them the next day, and the developer agent sitting there says, oh, no, we're not paying you. They were in here yesterday. They signed Mickey Mouse, but that was them. Okay. And guess what? The fight is on, right? So, he contacts me and he says, what can I do? And the first question I asked him was, did you have a buyer representation agreement? And he goes, I knew you were going to say that. I'm sorry. I've been doing this too long. Okay. I don't know, folks, I'm doing well over 100 transactions a year, and I do this. So there must be something in it, but you got to know what it is. And again, I'm happy to help you. And that's why we're here today. Free, I'm teaching you and I'm preaching to the choir. You all are wonderful for being here. I really so appreciate you being here. But these are things we can get past, right? These are little things. Okay. It's just like, but I got to make that decision. I want to go ride my bike. I want to ride up and down the coastline. Okay. But I got to work with this buyer. But I know that if I'm going to give up riding my bike up and down the coastline, I got to know that this buyer is going to make sure I get paid. Otherwise, I'm going to go ride my bike. Okay. Everybody get it? All right. Okay. If anyone other than the buyer compensates you, so whoever it is, can be anybody. They can have their nephew come in and give you a check. Okay, that amount shall be credited towards the buyer's obligation to pay commissions. Does everybody understand that? So that's the answer to the question. What happens if they agreed to pay 3% and then the other side is only going to pay 2.5%? Then they agree that the 2.5% will be applied to the number that they would owe you, the 3%, and now they owe you a 0.5 point. And I'm going to tell you something. I see that scenario, and I rarely ever have a problem with it. I send over page 1 of our buyer representation agreement to the escrow company, and the escrow company just puts it on the balance sheet and has the buyer. It's just an additional cost for the buyer at closing. Okay. Daniel, in 1A, it asks for, we're in 3. Location of the property. Assume you are having the buyer sign this document when you're making an offer. And the answer is yes. So I have and we covered 1A earlier. And so that's on the webinar. I'm more than happy to send it to you. But the answer is, yeah, I identify the properties, whether it's an individual property or an area, things like that. Okay. All right. Now, if the compensation, what happens? So we talked about if it's, it's the same amount as I'm charging, then we're even. If it's less than I'm charging, then they have to come up with the difference. And again, I just never had anybody, complain about it. But what happens in the scenario where it's more than the amount of money that you're asking? Okay. So what happens if in fact, your agreement with them says 3%, but the listing agent's paying you 4%? Okay. You have a whole point difference. So what do you got to do? You can't just take the 4%. Everybody understand? You can't just take the 4. That's secret profit. You have to notify your buyer that you are being compensated 4%. And that's all that the law requires. They just require you to notify the buyer. Okay. So if the amount of compensation the broker receives from anyone other than the buyer exceeds the buyer's obligations, then the excess amount shall be disclosed to the buyer, and if allowed by law, paid to the broker, which it is allowed. Check with your attorney. Okay. Paid to the broker. Or you could give it back. I don't know why. You work hard for your money, and then you have that one day where you get a windfall, and the law says you got to tell the buyer about the windfall. Guess what? I'm getting an extra point. So not only, I always say, you know what? You don't have to compensate me. Don't worry about it. In fact, they like my service so much, they're going to compensate me more than what you agreed to pay me. Okay. And that's, rare enough, but I'll take it. All right. Okay. Don't give up your money just because somebody's, offering to pay you money. All right. So again, you have 3 scenarios. 1, it's the same amount as your agreement, in which case, no harm, no foul. Buyer pays nothing. If it's if the offer of compensation in the MLS is less than the amount that the buyers agree to pay you, then you collect the difference, or you do whatever you want to with it. It's up to you. Okay. Or what happens if the money is more than the amount that the buyer agrees to pay you? Then in that scenario, you must disclose that there is additional compensation. You must disclose the excess amount. Okay. And then move forward. Or you might decide to credit it back to the buyer, which, all right, fine. Do whatever you want to do. Everybody good? Questions? My favorite subject. I love commissions. Okay. All right. Let's, and feel free to ask questions, and then I'll see if I can answer them if we're in the same thing here. Okay, let's take a look at paragraph number C. Now in C, it says the broker's right to a compensation, all right? So the broker shall be entitled to compensation in 3A, 1, if during the representation period or any extension. Remember, you can always extend this. And one of the things we talked about earlier was that, you might have you could have a weekend on your buyer representation agreement. The buyer loves you so much, they want to extend it to another weekend. Okay, so, or any extension thereof. Buyer enters in an agreement to acquire property described in 1A, so within the zip code, within the area, whatever. Again, we don't use big numbers like all of San Diego County. It's just not going to be enforceable. Okay, all right, on terms acceptable to the buyer, so the buyer agrees, provided the seller completes the transaction. If the seller doesn't complete it, then we're going to talk about what we're going to do about that. Okay, provided the seller completes the transaction or is prevented from doing so by the buyer. Okay, all right, so that's my scenario. I'm getting paid. Broker shall be entitled to compensation whether any escrow resulting from such agreement closes during or after the expiration of the representation period. Okay, and we're going to define what that looks like. All right, so in other words, you close a transaction. I had this happen. I was running San Clemente and San Diego for the Red people. And, I had one of my agents up in San Clemente calls me. I'm in the office, calls me up and says, I just looked up, I haven't heard from my buyer since August, and, it's January. And I just found out they bought a house. And I go, really? Did you have the buyer representation agreement? Yeah, I did. And I go, did it cover the period in which they bought the house? Yeah, it did. I said, no kidding. Really? They bought the house. And what did they say when you called them? They said, they wouldn't answer my call. No kidding. So, God, just at that moment, our corporate attorney came walking by the front of my window in my office. I handed him the phone. I said, here, talk to your agent. We got a $30,000 check from the buyer. So anyway, yeah, guess what? They are enforceable. Okay, all right. Requires buyer, where did I go? Broker shall be entitled to compensation whether, or even after that period, as long as it's entered into during the time of this agreement or any extension thereof. Okay, let's talk about paragraph number 2. If within so many calendar days after expiration, you're all going to remember what this is because you remember it was on the state exam. So on your listing agreement, you have what we refer to as the safety clause or the protection clause that protects the broker in the event that the parties decide to get together after this thing expires. So how many days do you put in there, right? I don't know. It's up to you. On buyer representation agreements, we like 90 days. Okay, we know that that's enforceable. 180, a year, probably not, right? Okay, but we want to make sure that there isn't any misunderstanding that the buyer thinks that if they wait until the day after our thing expires that they don't have to pay us compensation. Okay, so we like to put in 90. You put in whatever you want to put in. Okay, or any extension thereof. Buyer enters in an agreement to acquire property which the broker introduced to the buyer. So now, see, these are the things you got to listen to because this is the part where the buyer wiggles out of stuff. All right, so or for which the broker acted on buyer's behalf. And by the way, you have to introduce the buyer to it. It's not, and courts have held, you don't just send them the listings in an automatic drip campaign or whatever. That does not constitute introducing it to the buyer. They want you to physically introduce it. Same question is going to appear on the listing agreement, right? Okay, all right. So if which the broker acted on buyer's behalf, the obligation to pay the commission shall arise only if prior to or within 3 days after expiration of this agreement. Now, again, different than the listing agreement. We changed the listing agreement to say that you had to give the seller a list of prospective buyers before it expired. But on the buyer representation agreement, you don't have to give the list of prospective properties until 3 days, within the 3-day period after it expires, unless you change that term, okay? But a broker gives the buyer a written notice of those properties. So we actually had the form at SDAR called the Notice of Prospective or Notice of Properties, Buyer's Properties, and then CAR copied it, and there you go, they're off to the races. So gives a notice of those properties which the broker introduced to the buyer or for which the broker acted on the buyer's behalf. Everybody understand? So I want to make sure that it's not just a list. I need to at least have introduced them to the property. Now, clearly, folks, if you show them the house and then they're looking at their contract and their contract says it expires on, Monday, and then the offer gets written on Tuesday, you're going to really wish that you had filled this part out. Okay, you follow me? All right, so it's going to be really important. All right, everybody good? Questions on any of that? Because I am going to move on to the next question. Y'all ask really good questions. Thank you. Okay, let's go to, well, we're wrapping it up here. Let me see how many more we got. We got one, two more. Okay, so let's talk about timing of compensation. So compensation is payable, okay, one, upon completion of a transaction, okay, whether escrowed or not, okay. Two, acquisition is prevented by default of the buyer. The buyer says, changed my mind. Upon the buyer's default, it is due now, okay. Three, if acquisition is prevented by a party of the transaction other than the buyer, and then the buyer collects damages by suit, settlement, or otherwise, okay, then the compensation is due to the broker. So if somebody other than the buyer prevents the transaction from closing, and then the buyer sues or does something and receives money, you are entitled to a piece of that money. So how much are you entitled to? Shall equal 1/2 of the damages recovered. Okay, not to exceed the compensation provided for in 3A. So if you put 3% in 3A and they receive 10%, then you're not allowed to get more than 3%. Okay, after first deducting the unreimbursed payments, credits, and expenses of collection, if any. Don't you hate to think that you have to go after your buyer for your money? It happens all the time. We got to go after the buyer, right? Okay. Any questions on any of that? So now I know I've really only got 3 scenarios. You complete the transaction, in which case you're being paid. The buyer sabotages the transaction, which now the buyer owes you the money now. Or 3, somebody else prevents the transaction from closing and the buyer recovers money against them. You can't recover from the buyer if it wasn't their fault. But if the buyer recovers money from somebody who was at fault, whatever that is, you're entitled to either 1/2 or your commission, whichever is less. Okay? That's fun stuff, I think. Everybody good? Questions? See none? Okay. We're going to go to, I'm pretty sure, oh, one more. Okay, yeah, sorry about that. All right, so number E, let's talk about E. Buyer hereby irrevocably, one of my favorite words, assigns to the broker the compensation provided in 3A from the buyer's funds and proceeds in escrow. So the money the money the buyer brings in, you're getting paid out of that. Buyer agrees to submit to escrow any funds needed to compensate the broker under the agreement. So if in fact it turns out that the buyer owes 1/2 point, they'll bring in 1/2 point. Okay. Good. All right. Okay. Broker may submit this agreement, as I said earlier, as instructions to compensate the broker to any escrow regarding the property involving the buyer and a seller or other transferor. Okay. Everybody good? All right, so as I said earlier, I'm going to submit this to escrow, and I do expect to be compensated, okay? Buyer includes any person or entity other than the broker, okay, related to the buyer, okay, the wife, the corporation, the company, or who in any manner acts on the buyer's behalf to acquire the property that is listed in 1A, all right? So, and trust me, it's like everything else. When it comes to this kind of money, everybody's looking for a way to wiggle out of the deal. It's hard enough for you to get paid in a transaction. You have to at least try, right? Okay. All right. So they'll come up with all kinds of creative stuff on how they're going to get around the deal. In our conversations with Veronica, the deputy commissioner, just a few moments ago, we were laughing about creative realtoring, the stuff that we come up with to try to get around the rule. And it's probably the #1 question that I get. People will call me all the time and they'll say, "Hey, Kev, I know what the law says." And then I'm waiting. And then when they say, but, I know the but part is going to be, how do I break the law? And I always tell them, I'm not going to help you break the law. I'll discuss the law with you or whatever it is, but I'm not going to help you break it. Okay. That's the reason I've been the chair of rules committees and heads of professional standards and all kinds of stuff over all these years. And the reason is because, these are, I'm always going to get that question that says, how do I get around the rule? Okay. All right. Everybody good so far? I'm going to move us on to our last section here, which is going to be paragraph number G. And number 1, buyer has not, now folks, I'm going to tell you, this is really important. You really have to have this conversation with your client. All right. And it's the same thing that holds true in our listing agreement. And I'm going to explain to you why. And this is a problem. Buyer has not previously entered into a representation agreement with another broker regarding property described in 1A. They could have done it in another area. So if in 1A you said 92014 zip code, and then they go on and enter into an agreement with 92104 zip code, Okay, all right. But they are going to tell you here that they are not involved in any agreement in the same zip code or in the same area. And if so, give us the name of that other broker. So you have to have this conversation, because sometimes they do. Sometimes I don't know what I signed. I get, I didn't know what I signed. Okay, well then, yeah, right. Okay. So number 2, buyer warrants that buyer has no obligation to pay compensation to any other broker. That's a different question than number 1. All right, regarding property described in 1A, unless the buyer acquires the following properties. So in this scenario, it may very well be that, there are these 3 properties that they agree to pay another broker compensation for. It's unfair for you to get the buyer to commit to 2 different brokers to pay 2 different compensations. That's unfair. All right. And again, specifically for the subject matter of this agreement. So that's why we need to ask them the question: do you have an obligation to pay anybody else on any property in 92014? Okay. That's why we have to ask the question. Okay. It's just not fair. All right. And the law doesn't like, you've heard me say it before, what is fair? Fair is a place we show pigs. Right. But at the same time, there's that court of law and the court of equity. Court of equity says it's just not fair. Okay. All right. So you got to ask the question. Okay. And then finally, number 3, if the buyer acquires a property specified in G2, which is up here, if they acquire that property during the time the buyer is obligated to compensate another broker, so they did have a compensation thing, then the broker is neither 1, entitled to compensation, nor 2, obligated to represent the buyer in such transactions. So I want to eliminate my relationship with the buyer at the same time that I'm also dispelling any obligation by the buyer to pay me a commission. So, but remember that that number 3 falls underneath number 2. Number 2 says, do you have anybody that you're supposed to be paying? And I see this kind of shined over so many times with agents where they don't ask these questions. They just have their buyer sign the form, and then the buyer comes back later on and says, well, I didn't know that there was going to be a problem if I've got somebody else representing me on this house in 92014. And it says right here that, but my agent didn't explain that to me. So you don't want to get into the he said, she said part about things. You want to be professional about your business. You want to sit down in front of the client and you want to go over the form with them. And as I said earlier, like my transfer disclosure statement, things like that, don't just drop it on their doorstep and say, let me know when you filled it out. You have an obligation to advise and counsel your client, and we want to make sure that you're doing that. Okay. All right. So that is where I am at the moment. Questions? Anybody have any questions? I'm looking here. I'm not seeing any. Well, you're a great group, but let me tell you something. Well, not because you didn't ask any questions, but I got 9 really good questions in here today. Those are good questions. You're all on point. It shows me that you're listening, but at the same time, I want you to get paid. I mean, it's a big deal, and I'm not asking you to do anything that's not normal in 49.5 states. All right, because it's normal for people to get buyer representation agreements. Your buyers wonder why you didn't do it. I've had it happen. I had a buyer come in from Connecticut and they go, well, when are we going to sign the buyer representation agreement? And I'm sitting there going, oh boy. Okay, that's funny. A buyer knows more than I do, and that's kind of a scary thought. Describe the Marco sold properties that you demonstrated on the Coronado Caravan this morning. Can you briefly describe the Marco sold properties? I don't know what that you demonstrated on the Coronado Caravan. Macro. Daniel, I'm not sure if I understand the question. Describe the macro sold properties. I didn't have any properties to sell on the Coronado Caravan this morning. I discussed the fast stats on how to create your document that shows you statistics. Okay, so fast stats is in go to the SDAR website and just click on fast stats and then just type, I do a whole class on it. In fact, it won't be tomorrow morning because tomorrow morning I'm doing CRS tax data, but the following Thursday morning, I'm going to do a whole hour on it. On that. Or you know what you can do? Go onto the SDR website and look at my recording. So you can look at education courses, look at previous webinars, and it's in there. Okay, I'll do a whole fresh one coming up in a week and a half, but that's the best way to do that. Okay, and then thank you for your earlier question on agency disclosure, because I think agency disclosure is the one thing I assure you we miss it. And you know what? I'll tell you, if you don't understand agency, you will be grilled on this subject. I have had trials where I have proven that the agent who they both work in the same brokerage firm, both on the same team, I was able to prove to the jury that it wasn't a dual agency. You and I call it dual agency, but I proved that neither one of them knew what the other was doing, and they were very careful about documenting everything that they did. So agency is such an incredibly misunderstood concept in California, but I am encouraging you to understand it, and it starts with just reading the form. So Daniel, send me an email, and I will send you the link to the SDAR, the website, where you can go to do the fast stats. And like I said, I just did a bunch of them. I did them for Coronado, Encinitas, Carlsbad, Oceanside, did all that this morning on the caravans. Go to the pitch sessions, because there's a lot going on there. Nancy, you know, right? You go to the pitch sessions in Del Mar, you learn more by going to the pitch session than any other time. So, okay. So barring any other questions, I want to thank you all for being here today. I appreciate the value of your time. And if you have any needs, I'm going to pull up my, let me pull up my, my contact information again. As I told them this morning, I said, you know, at least if you're going to, you know, if you got a complaint, make sure you spell my name right, but hopefully I've got it right. And I do want to help you. You know that my goal in life is to make sure you look good, right? If you look good, I look good. So, you know, I need you to look good. I really do. And I'll help you in any way that I can. And I absolutely thank SDAR for giving me the opportunity to present with you today. And again, if you have any questions, Claudia, thank you so much. Very kind of you. Nancy, you're wonderful always. But if there's anything I can do for you, if you will please let me know. Send me an email. There it is on your screen, Kevin@BurkeRealEstateConsultants.com. You know, I'm happy to help. Okay. Thank you all. Galena, thank you always. Thank you for being here. And my very best to all of you. And I hope I get to see you tomorrow morning for CRS tax data. Or if not, in the afternoon, we'll be doing the purchase agreement. I hope you all have a fantastic evening. So take care for now. Bye-bye.